Center for the Study of World Religions, Harvard Divinity School.
Welcome to the panel on law and psychedelics. I'm Mason Marks. I'm a law professor at Florida State University. I'm also the senior fellow of the psychedelic projects at the Petrie-Flom Center for Health Law Policy, Biotechnology, and Bioethics at Harvard Law School. We have two psychedelic-related projects at the Petrie-Flom Center. Poplar is our first program that we founded in 2021. Poplar is the Project on Psychedelics Law and Regulation. And we started a second program about 2 years ago called Pulse, which stands for Psychedelic Use, Law, and Spiritual Experience. And there's been no shortage of things to write about and talk about and hold events and conferences for in those past few years. We have a handful of psychedelics that are working their way through the FDA approval pipeline, things like LSD of all things, DMT, of course, psilocybin, MDMA, and we might see FDA-approved psychedelics in the next few years. There are also, as you know, many psychedelic churches that are popping up. We're at the Divinity School. There have been a lot of panels about churches seeking exemptions under RFRA to practice their religious exercise rights. We've also seen states like Oregon, Colorado, and New Mexico enact new laws to legalize or decriminalize a variety of psychedelics. And there are lawsuits. For example, in Oregon, there's a lawsuit filed on behalf of people with disabilities to make the Oregon Psilocybin Services program more accessible so that people who cannot leave their home and go to a service center can access psilocybin. There's a petition at DEA to reschedule psilocybin. And we have an amazing panel of experts today to talk about a variety of different facets of this unfolding psychedelic legal landscape, including the ongoing marijuana rescheduling process and what it might mean for psychedelics like psilocybin. We'll hear about ethics and conflicts of interest in psychedelic research. We're going to talk about grifters and the influence of the wellness industry on psychedelics. And we'll also hear about some Indigenous cultural practices and how they might mesh or not mesh so well with some other models of psychedelic policy reform. Before I go any further, I want to just thank a group of people, specifically the SciSay Foundation, Tim Ferriss, Matt Mullenweg, the Gracias Family Foundation, the Mahindra Humanities Center, and the Petrie-Flom Center staff, Glenn Cohen, the faculty director, Susanna Baruch, the executive director, Laura Cheung, Lisa Gorelick, and Aaron Lynch for all their support in putting on these events. Just a few logistics about our panel. We have a lot of people, so I'm going to ask our panelists to limit their remarks to 15 minutes or so, and we do have a couple papers that are represented by two speakers, so we can kind of fudge the rules a little bit, maybe about 18 minutes, and then hopefully we'll have a very full discussion with all of you, and the panelists will engage each other. And perhaps you saw Noah Feldman's keynote yesterday, which was excellent. And I just want to pose a question to all of you and to the panelists. Professor Feldman described the law as one of the sources of resistance to progress in the psychedelic landscape. So I just want to have you ponder whether that's entirely true. Is law always a source of resistance to progress in this space? Is it more neutral, or are there even instances in which the law might facilitate progress in the psychedelic landscape? I think we might have some speakers who want to say a little bit about that, perhaps. All right, well, I'm going to turn things over to our panelists. I'm going to ask each of them to introduce themselves, and we'll start first with Alex Kreit. So welcome, Alex.
Thank you so much, Mason, and it's great to be here. Great to be with such a fantastic group of panelists and to see so many folks getting up for this early law-themed panel, which hopefully will not put everyone to sleep, especially my discussion of the Controlled Substances Act, which is not always the most, fun-filled, engaging thing to be thinking about. I am Alex Kreit. I teach at Northern Kentucky University Chase College of Law. I am going to talk about the Controlled Substances Act and the marijuana rescheduling petition, which is currently pending, and what implications it could have for psychedelics. I'm not going to have any grand takeaways, in part because the marijuana rescheduling petition is still going through the administrative process. But I do think there are things about it that do have potentially important implications for psychedelics, and I'm going to talk about that. I've been, researching the Controlled Substances Act's scheduling criteria for a while, and as I'll talk about here in a moment more, it's incredibly open-ended, and sort of the longer you spend looking at it, almost the more maddening it becomes. And at some point a few months ago, as I've been sort of over the years, I've read a lot of memoranda and other things written by Michael Sonnenreich, who, as many might know, he was the deputy chief counsel for the Bureau of Narcotics and Dangerous Drugs, predecessor agency, the DEA. He was sort of the chief author of the Controlled Substances Act. And it occurred to me a couple of months ago, he's still alive. Maybe I should see if I could talk to him and glean any insights about, what they were thinking with these sort of inscrutable Controlled Substances Act scheduling criteria. And I did have the chance to talk with him briefly. He's in his 80s. His memory's not the best, but he was really gracious with his time. I didn't get any really sort of especially practically useful insights, but he did say something to me that I thought was maybe a good place to start. He said, "I can't believe they're still screwing around with that act after 56 years." And he said to me that he'd written an act for 10 years. He did not think it would last past that amount of time. And I feel like probably any of us who spent any time looking at the Controlled Substances Act would probably agree with that sentiment. It is not a model of clarity, to put it mildly. So turning to the sort of Controlled Substances Act scheduling criteria, the CSA, before it was passed, this was not by a long shot the first federal anti-drug law. The CSA, I think, was in large part, the genesis of it was to try to take what had then been a hodgepodge of federal drug laws dealing with a variety of so-called drugs of abuse. The Marijuana Tax Act, the Harrison Narcotics Act, the Anti-Drug Abuse Amendments of 1965, which had all been sort of housed in different parts of federal law and had differences in how they dealt with different, again, so-called drugs of abuse, and put it under sort of one legislative home, right? I think that was the main genesis of the Controlled Substances Act. And at the core of the Controlled Substances Act, of course, is this scheduling system, which divides controlled substances, and a controlled substance is potentially any drug that has a sufficient threshold of potential for abuse. If there's a sufficient threshold of potential for abuse, the drug can be scheduled under the Controlled Substances Act, and you've got this 5-schedule system. The big dividing line is between Schedule 1 and Schedule 2, because substances in Schedules 2 and below have a medical use and can be distributed potentially legally for medical or research purposes. Substances in Schedule 1 can only be distributed for research purposes. I won't go through any sort of detail about the differences between the schedules beyond that, other than to say, as you might imagine, the lower the schedule, generally speaking, the less restrictive the controls and regulations. The higher the schedule, the more restrictive the controls and regulations. I'm going to be focusing on the currently accepted medical use in treatment in the United States provision here, which again is sort of a big dividing line in the scheduling of substances. And this is a provision that is, I think, sort of particularly difficult to make sense of, and hopefully you'll see that more as I go along. And in large part, I think it's because, first and foremost, Congress never gave a definition to any of the scheduling criteria. And the only thing literally in the scheduling criteria that Congress defined was the term United States, which Congress tells us, helpfully, here's what United States means, but what does currently accepted medical use in treatment mean? who knows, right? Like, let's just not define that part. And, you know, there's different views among legal academics and courts and lawyers about the extent to which it's appropriate to look to legislative history to try to determine the meaning of statutes. But when you look at the legislative history here, if you are somebody who subscribes to thinking about legislative history, that's not particularly helpful either. There's surprisingly little discussion of the scheduling criteria as the Controlled Substances Act made its way through Congress, and particularly surprisingly little about this currently accepted medical use and treatment in the United States. The little that there is, a lot of it is sort of comically naive sounding when you read it. Is one example. This is from a House report where they said, if it were to be determined that LSD, when injected in the body of a cancer victim, is a cure for cancer, then the Bureau, it's the Bureau of Narcotics and Dangerous Drugs, could move it from Schedule 1 to Schedule 2. I mean, I guess I should hope so if that somehow were to be determined, but determined by who, like through what process, right? Like, I mean, there's just very, very little discussion about what Congress may have had in mind with respect to this idea of currently accepted medical use in treatment in the United States. And in the absence of any clear indication in the text or even the legislative history about what Congress may have had in mind, the Drug Enforcement Administration has, to date, enjoyed a great deal of discretion to define this term. And a big part of that is because of what was known as so-called Chevron deference. Basically, courts deferred to administrative agencies and their interpretation of statutes. The Supreme Court overruled Chevron a couple of years ago, and so that deference has gone away. And that's one of the things that is opening up, I think, in the context of marijuana rescheduling, the possibility of a sort of transformed version of the Controlled Substances Act that doesn't rely on the DEA's definitions of these scheduling criteria. But the DEA in 1992 came up with this controlling test that has lived with us ever since. And I won't discuss the history of what happened before 1992. If we want to, we can talk about that in the Q&A. But in 1992, DEA came up with this 5 requirement test for determining whether or not a substance has a currently accepted medical use in treatment in the United States. And this test was designed, and DEA said so sort of expressly in the administrative filings in which it described this test and came up with this test. It was intended to mirror the substantive requirements for approval by the FDA under the Food, Drug, and Cosmetic Act. Now, this test doesn't require actual FDA approval, but is intended to require basically the substance of what you would need in order to get FDA approval of a drug. And so, the adequate and well-controlled studies proving efficacy, that specifically has the meaning of the exact kind of studies that you would need in order to get FDA approval for a drug. Turning to the marijuana rescheduling petition, if you sort of look at these criteria, I think 2 in particular have stood out as significant barriers to marijuana rescheduling. One is the adequate well-controlled studies, because while there is evidence of marijuana's medical efficacy, there are not the kinds of studies that you would need in order to get FDA approval for a drug. And the other has been that marijuana, whether its chemistry is known and reproducible. And I'm using the term marijuana here, not cannabis, because that is the term in the Controlled Substances Act, and marijuana rescheduling, if it concludes, will be to the substance defined as marijuana in the CSA specifically. And that substance, as defined in the CSA, the chemistry is not known and reproducible because there are many strains of marijuana, right? This is just sort of the marijuana plant writ large as defined in the CSA, and that chemistry is not known and reproducible. So what leads to this 2024 rescheduling petition that was the notice of proposed rulemaking that was filed in May of 2024 by the Attorney General was a new proposed test for currently accepted medical use in treatment in the United States by HHS, right? It's not that marijuana's chemistry suddenly became known and reproducible, or suddenly there was a bunch of trials that, we haven't heard of that would meet the FDA requirements. It's that HHS looked at this and said, we think that DEA's test is unduly narrow. And HHS's test requires this sort of widespread current experience in accordance with implemented state authorized programs and whether there is some credible support for at least one medical use. Why is HHS able to come up with this test? HHS has a role in the scheduling process, which I won't go into, but for those who are interested, our moderator Mason has a fantastic article that I think from last year on this very topic of HHS's role in the scheduling process. So I highly recommend checking that out for those interested in HHS's role. But suffice it to say, the Controlled Substance Act requires the DEA to seek HHS's input on scientific and medical questions as part of the scheduling process. And as that happened, HHS said, you know what? We don't think DEA's test is the best test here. We're going to propose this new test. And the interagency dispute led the Office of Legal Counsel, which basically provides opinions about these kinds of legal questions. Their opinions are not, they don't have the force of law or anything. They're just the opinions of this office housed within the Attorney General's office, but they're generally very well respected and thought to be, courts pay a good amount of attention to what OLC says generally. And OLC looked at these tests and said, we think that the DEA's test is impermissibly narrow. Impermissibly narrow with respect to the phrase currently accepted medical use and treatment in the United States. And we think that OLC's test falls within the basic parameters of the CSA. And I can talk in Q&A if folks are interested sort of more about why OLC came to these conclusions. But for, in the interest of time, I'll sort of turn to thinking about what this might mean for psychedelics, right? The marijuana rescheduling petition is still pending administratively, and who knows when we will have a conclusion to it administratively, let alone in litigation. But when we think about sort of what this process might mean for psychedelics, at first glance, when you look at the HHS test, it doesn't seem, I think particularly promising for psychedelics either, because of requirement number one, right? That there be widespread current experience with medical use in accordance with with implemented state authorized programs. Now, of course, you have Oregon, you have Colorado, you have New Mexico, in the offing, but you don't have widespread current experience with medical use with state authorized programs, assuming, here even that HHS would consider under this test those programs, the use that is occurring within those programs to constitute, what they're conceiving of as medical use here. And so, this seems to be, and I think Rob Michos, law professor at Vanderbilt, has said sort of a test that seems designed that only marijuana could meet it, at least now, right? That basically marijuana is the only substance that has all of these state laws that have been around for, decades now, some of them. And, the pending petition, or the petition that was filed, it's now at HHS for its evaluation for rescheduling psilocybin, it asks only for movement to Schedule 2. And the reason for that is that petition says that this is a drug that has a currently accepted medical use with severe restrictions. Not, that petition doesn't say this is a currently accepted medical use generally. And the thing that I think the big takeaway that I want to leave folks with, and then in Q&A, maybe we can get into more of the details, is this HHS test is not, now the law either. The most important, I think, implication of rescheduling, the marijuana rescheduling petition for psychedelics, is it is opening up the definition or opening up the question of what the definition of currently accepted medical use and treatment in the United States is under the Controlled Substances Act. And in any litigation over marijuana rescheduling, which I suspect will occur, courts are going to now be deciding what is the meaning of that term. And the HHS test, the first part of it, I think there's a pretty good argument that it is unduly narrow because it requires widespread violations of the Controlled Substances Act in order to be satisfied. And so I think that psychedelics advocates who are interested in rescheduling, and of course, rescheduling apart from the rescheduling that would occur with FDA approval of a substance, should be paying pretty close attention to the marijuana rescheduling petition, particularly with respect to the question of what is going to be the meaning of currently accepted medical use in treatment in the United States at the conclusion of those proceedings. Thanks.
I don't think there are that many people who are as interested in the history of the Controlled Substances Act as Alex is. So I really appreciate that. We'll hear next about conflicts of interest in psychedelic research from Katherine and Daniel.
Hi, good morning. So the work we're going to be presenting today was really motivated from a perception from the public and also from a number of media pieces that psychedelics research is rife with conflicts of interest. And although some of these contentions have focused on financial conflicts of interest, in fact, much of the focus has actually been around non-financial conflicts of interest, which is a growing area of focus outside of psychedelics, but also specific to this field. So to start, what do we mean with these terms? Well, more generally, we can begin with Dennis Thompson's off-cited definition of conflicts of interest, which I'm going to refer to as COIs going forward. And he terms a COI as a situation in which an individual's judgment concerning a primary interest tends to be unduly influenced or biased by a secondary interest. So in this understanding, there's this basic agreement that the primary interest in research is its integrity. And to be clear, the secondary interest is often important in some cases, but its relative weight in these professional decisions is what we consider problematic. So the standard example here would be a researcher conducting a clinical trial of a drug while holding stock in the manufacturer. I think most of us are familiar with that. But while the ethical and policy debates concerning COIs initially focused on this aforementioned financial COI, there's now this growing attention to non-financial COIs, NFCOIs. And so by extension of this definition, an NFCOI is where the secondary interest does not involve a monetary factor. And so a relatively uncontroversial example would be a journal editor that's reviewing a submission by their doctoral student. The primary interest here is an impartial peer review. And then the secondary interest is the mentor-mentee relationship and the editor's reputational stake in their student's success. So no money is changing hands, but fundamentally the editor's judgment is compromised by loyalty and by professional identity. But outside of these more clear-cut examples, there's a whole group of literature proposing a wide range of NFCOIs, from career ambitions to religious beliefs to personal relationships. So for example, in nutrition research, a number of people have argued that researchers should disclose their own personal diets as NFCOIs, arguing that these diets shape study design and interpretation. And that may sound strange, but actually there's some real correlation between these things. Gambling researchers have contended that those who hold strong moral or ideological opposition to gambling should disclose that position. And in climate science, a number of researchers have argued that scientists who become climate activists risk holding a priori interest in their study outcomes and have called for conceptual and practical separation between climate research and climate advocacy. So we have a separate paper sort of getting into, whether we actually view how we view the legitimacy of some of these arguments and some of the answers to that. But without sort of delving too deep into that, I think it's clear that this is a growing area of concern. And for those of you who have followed the ACIP committee, some of the debates around what Secretary Kennedy called financial conflicts of interest in this committee, now others have called the new ACIP committee rife with non-financial conflicts of interest, those who are more ideologically biased. And journals are already struggling with this question. A 2016 study found that 50% of core clinical journals are requiring disclosures of NFCOIs, but they're not consistent with their language. And that inconsistency is important because it can be confusing for the researcher in terms of what they're actually being asked to disclose, but also can be challenging for the reader when they're trying to interpret that disclosure to understand what it is that they're actually perceiving. And then this returns us to psychedelics. So some of the contentions have come from media, as I noted, as in this New York Times piece that argued that the enthusiasm and belief in legalizing psychedelics has trumped adherence to scientific protocol. But it's also an evidence review. So in the ICER report about Lycos, they noted significant concerns about investigators' enthusiasm for psychedelics leading to systematic bias in both how benefits and harms were recorded. And I think this is all the more noteworthy in a field where many trials are functionally unblinded. And I guess in tandem with these accusations, there's this broader phenomenon in our field of psychedelics that researchers who study psychedelics are disproportionately likely to have used them personally. A recent study found that 83% of psychedelic researchers reported having used them at least once in their lifetime, compared to about 15% of the overall US population. And so that kind of gets us into where we want to go today. I think NFCOIs are important in this field because they can erode public trust. There's a study that shows that when researchers admit to personal psychedelic use or ties to psychedelic culture, people rate their scientific integrity and research quality lower. And if regulators perceive investigators as advocates rather than as, say, disinterested scientists, they may discount the supporting evidence entirely. But I think the question isn't really whether NFCOIs exist, they clearly do, but more whether they actually affect how the public receives and trusts the science. And that kind of leads us into the study that we're presenting today.
Thank you. So our study really aimed to examine the impact of NFCOIs on two separate areas. So the first being how they would impact readers' confidence in a study's results, and the second on how they would affect perceptions of the trustworthiness of the researcher themselves and their likelihood for bias. And so we're also interested about the impact of NFCOI disclosures between psychedelic and non-psychedelic fields. So in other words, is there something about psychedelics specifically that are raising these concerns? And so to preview in the study, we focused on three specific NFCOI disclosures: involvement in advocacy, commitment to a theory, and disciplinary training. So to give a brief overview of the design of our survey, we used Prolific to recruit a sample of the lay public. Prolific is a survey tool that's used to collect research-grade survey data. It's similar to MTurk, but outperforms it in terms of attention checks, honesty, and comprehension. We randomized participants to one of two conditions. So they would either receive a series of vignettes that described a hypothetical clinical trial on psychedelics, or a series of vignettes that would describe a clinical trial for a novel investigational drug, or what we've called Neuromedics 12, to treat depression. Both arms would receive 5 COI statements spanning financial and non-financial COIs, and we randomized the order of these to minimize response bias as well. We also included an open-ended follow-up question after each COI statement to capture participants' reasoning about how they were rating trustworthiness and likelihood for bias and their thought process. And so I've mentioned, we're interested really in two comparisons here. The first being between psychedelics and non-psychedelics. So we want to know whether identical NFCOI disclosures would have different impacts depending upon whether they were for psychedelic or conventional psychiatric research. And the second comparison we're interested in is across different disclosure types. So whether different kinds of NFCOI statements would affect the perceived trustworthiness and confidence in the results differently relative to an FCOI or no COI baseline. And to quickly go over our analysis plan, we used a linear mixed effects model to conduct our primary analysis, with our primary predictor here being the interaction of COI statement type, so financial or non-financial, and the vignette type, which is psychedelic or non-psychedelic. And we've included potential confounders like age, income, and political party in our models. So this is roughly the flow of our survey that we provided to participants. So you can see the two arms here. Psychedelic at the top here refers to the journal article on a psilocybin clinical trial for depression, whereas Neuromedics 12 here refers to the vignettes about a novel hypothetical investigational drug for depression. And so participants would receive all 5 of the COI conditions here, and with the statement order randomized. And to provide some context as to why we chose to include Neuromedics 12 as our comparator. So we wanted to see if there's some sort of psychedelic exceptionalism effect going on, or whether something about psychedelics would produce unique effects with regard to NF-COIs. So we chose a comparator that would also involve the same mental health condition or depression in both cases and the administration of a drug. And so these are the specific COI statements that we provided to participants to accompany the journal article vignettes. So we tried to make them as comparable as possible across the two arms, but there are some differences. So for example, for the advocacy one, the psychedelic arm has the researcher focusing on providing patients access to psilocybin therapy through expanded compassionate use programs and clinical trials, while the depression arm has the researcher focusing on lobbying for more insurance coverage for new treatments. And so for the commitment to the theory condition, we also try to pick up on views and debates that are currently ongoing in the field. So this one refers to the current debates on whether psychotherapy or just psychological support is necessary to accompany psychedelic treatments. So this is an example of our vignette that we provided to participants. So you can see that we provided them with the study title, the PI name, the rationale for the study, the methods, and a brief summary of the results. And so the disclosure statement is in blue here to make it a little bit easier to see for the presentation. And to also note that all of the principal investigator names are Dr. G or A, just a single letter, in order to minimize any bias related to gender or race, ethnicity in the responses. And so across the psychedelic and the depression arms, the preamble following the article would change, in addition to the disclosure statement below. This is the depression one. And this takes us to the preliminary findings.
Okay, we're really leaning into that conferences are good places to present preliminary findings and get feedback. So I want to flag that up front. These are preliminary unpublished results, and also please don't share outside of this room. So we fielded this to 894 participants on Prolific. It was roughly split between the psychedelic and non-psychedelic vignettes, and we're presenting on 2 outcomes of what we measured: how confident participants were in the study results and how trustworthy they perceived the researcher to be. So let's start with the confidence. The figure here plots mean confidence in study results by vignette domain and COI type. And as stated in methods, this is 95% confidence intervals. And we're only presenting the FCOI and NFCOI here because we haven't decoded yet the no COI group. So that's a clear limitation, I'll say up front. But from existing literature that have used some similar vignettes, we're kind of assuming that confidence and trust in researchers with no COI is likely to sit between 7.5 and 8.5. So keep that context in mind. So NFCOI statements really do affect confidence in the research, even when statements are as relatively tame as the ones that we presented to the participants. Overall, confidence is still higher in those with NFCOIs than FCOIs, as we expected, but they're still between 1.5 and 2 points difference, which was actually lower than we expected in terms of a difference. And then separately, while participants' confidence in the results across the 2 drug categories did not differ for NFCOIs, there was a small but statistically significant difference in participants in terms of how FCOIs impacted confidence in psilocybin compared to the antidepressant. And the why here is what we'd like to understand, and we're going to try to do this both through looking at open-ended question responses and also interviews that we'll refer to later on. But based on previous research, one plausible interpretation here is that respondents hold stronger feelings about industry influence in an established therapeutic market, like in antidepressants, than in an emerging field of psychedelics, where the commercial infrastructure is less familiar. And then this figure disaggregates the NFCOI conditions to examine whether these specific types of disclosures differentially affect confidence in the results. And you can see the three, as Kat mentioned in the methods, these three types of NFCOIs are plotted: advocacy, involvement, commitment to a viewpoint, and disciplinary training. I'd say our main observation here is just how narrow the range is. All three fall between 5.8 and 6.8, a span of less than 1 point. So overall, the variation within NFCOIs is substantially smaller than the variation between financial and non-financial categories. That said, there is clearly a small but statistically significant difference in confidence range for disciplinary training relative to advocacy and viewpoint for psychedelics, whereas there is not for antidepressants. And we're interested in why that is. One hypothesis is that participants may interpret specialized training as a marker of expertise in psychedelics rather than as a source of bias, but somehow don't in depression. So now moving on to trustworthiness. This figure disaggregates NFCOIs by type for the trustworthiness outcome, and a gradient emerges that was a little less visible in the confidence data, but overall it's a similar pattern. Advocacy sits the lowest, viewpoint commitment falls in the middle, and disciplinary training scores highest. And so, as I referred to, the rank ordering is consistent across both domains. I think maybe one of the more interesting findings is in this plot, which shows NFCOI trustworthiness that is slightly lower in psychedelics than in the antidepressants, but the confidence intervals do overlap. However, FCOI trustworthiness goes up in the psychedelic condition, and that is statistically significant. So this, in combination with the confidence findings, suggests the research domain really does seem to moderate how lay audiences interpret FCOI disclosures. In a conventional psychiatric context, industry funding seems to activate familiar pharma skepticism, producing the expected trustworthiness penalty. But in psychedelics, industry involvement may do so, but to a smaller degree. And again, these graphs are answering the what, not the why. So there's more to do in terms of understanding participants' reasoning. But hopefully we're going to get at that with some of the open-ended questions, which takes us to those.
So the theme is definitely that there is more to do. I'm going to caveat that there has been no analysis done on the open-ended responses yet. But for this presentation, we've just tried to select responses from our first look of the data that represent really the range of views that we see across the responses. And we're also just going to focus on the psychedelic ones for the sake of time. But for each of the COI conditions, the depression responses follow a roughly similar pattern. So for the no COI condition, we saw responses that were about in line with what you would expect. Most participants expressed that since the researcher had no competing interest to disclose, there is no reason to doubt the trustworthiness of the researcher or the results of the study. But there was a small group of participants that expressed that the phrase no competing interest to disclose made it seem like there were things that the researcher should have said but didn't, or as if they were trying to avoid discussing some things. For the financial COI condition, we also saw results that were fairly expected. A lot of the responses that we saw mentioned that since the funding for this research was provided by the manufacturer of psilocybin or Neuromedics 12, they would think that the research is biased or that the results are skewed. So in these quotes, we have participants describing that since the researcher received funds from the manufacturer, they might attempt to skew the results in order to see a positive outcome. But again, we have a meaningful group of participants that express that just because the researcher received funds from the manufacturer of the drug, it doesn't automatically mean the results would be biased. The COI would just perhaps be cause for more caution or skepticism about the results. So moving on to the involvement in advocacy condition. So here there was a wide range of views about participants' reasoning and their thought process when thinking through this one. So this participant treated involvement in advocacy as being fairly serious, even if no financial relationship was in place. But on the other hand, we also have participants expressing that involvement in advocacy actually improved their perception of the researcher. For example, it would make it appear as if they had altruistic motives or that they were conducting research for the good of the patient itself. We also had responses that were more mixed. So for example, in this case, the participant expressed that even though the advocacy organization and the researcher's involvement appears well-intentioned, the researcher would probably still have a bias towards wanting to show a positive outcome for the treatment and therefore there's cause for caution about the results of the study. And we see a similar range of results for the commitment to a theory condition, with some participants treating it as seriously as involvement in advocacy or financial COIs, while others thought it wasn't so much a cause for concern. So here, the participant describes that the researcher seems to have a preconceived belief that they just want to validate. Whereas this participant described their reasoning as being that commitment to a theory might be just as powerful as other COI conditions, but they would still give the researcher the benefit of the doubt, especially since the commitment was disclosed rather than hidden. So this might potentially point to the importance of disclosure for non-financial conflicts of interest. And we have a response here that's a little bit more mixed, saying that commitment to a theory is just a personal opinion, but it wouldn't affect the outcome of the research. And we also see a range of views for the disciplinary training condition. So as a reminder, the statement that we provided participants was that the researcher had a master's degree focused on psychedelics and mental health or depression in mental health. So this participant described their thought process as being that anyone who would get a master's degree specifically in the subject would want to see outcomes that support that field because, as they say, why would you spend so much time getting a master's in it if you weren't trying to rally support for it? Whereas some participants reasoned that having a master's degree specifically in that field, whether it be psychedelics or depression, would make you more knowledgeable or more qualified than other people to deliver clinical trial results, and they would trust the results more. And we also have more neutral responses, such as this one about how being an expert doesn't necessarily bias a result. So to summarize everything very quickly, I know we're at time. So although our analysis remains preliminary and we have the open-ended responses to go through in more depth, we can start with a few tentative takeaways from what we've seen. So the first thing that we see is that NFCYs appear to produce a significant impact on ratings of researcher trustworthiness and their confidence in the results based on existing literature around COIs. And we can also see that COI disclosures produce similar effects across depression and psychedelic vignettes, potentially pointing to a lack of a psychedelic exceptionalism effect here. And by looking at NFCY types, the disciplinary training was the only type that was penalized less in ratings of perceived trustworthiness in the psychedelic arm. So potentially suggesting that the lay public distinguished expertise from participation and advocacy. And similarly, from the open-ended responses, we can see that participants hold a range of views about involvement in advocacy and theoretical commitments, showing that NFCYs are not a monolithic category. So to move this work forward, some next steps that we have are to replicate the study with a sample of researchers, as they're really the primary target of academic articles of the type that we provided in this survey, and to conduct interviews with participants to better understand the nuances in their reasoning around this topic. So I'd like to send huge thanks to Rebecca Ehrenkrantz and David Yaden for their support for this project. And thank you very much.
All right, we'll hear next from Laura and Jennifer.
Okay, good morning. Thanks for all being here. Thanks to Jeff and Paul and Susanna and Mason, to CSWR, Mahindra, Petrie-Flom, and the Div School for hosting. So I'm here to put a pin in the happy bubble of the psychedelic renaissance, right? So enter the lawyers. And what Jennifer and I want to talk about today is what we have identified as the dark side, which we see as an unholy alliance between profit-seeking social media wellness grifters, that's the title, Silicon Valley biohacking tech bros, and Maha health freedom advocates. So my part of this is to talk a little bit about the historical and maybe some doctrinal links between wellness grift and psychedelic commerce. And I think we're hoping to talk about the difficulty of carving out the ethical line between pursuit of personal healing and exploitation. So today, I think it's safe to say there is a lot of anti-institutional sentiment and deregulatory ideology. And that has produced a legally ambiguous, profit-driven therapeutics. And that, unfortunately, has drawn in some psychedelics. And what we are trying to do is really situate historically the psychedelic wellness boom within a very particular American tradition of exceptionalism, because by golly, we are special, right? So, and we argue this is really a specifically American lineage, born of three things: our anti-elite attitude, which I think we see in politics, some skepticism towards scientific authority, and the valorization of a lot of individualized back to nature healing. Is this the little slide thing? Sure. No, okay. Okay, right. So, and I think this specific moment, we really have a corrective to the perceived failures of big pharma, right? So that's the bottom, little money pill. Fear of governmental overreach. And I think a lot of concern over recent missteps, either real or imagined, of science and medicine. I think this is particularly true after COVID. And so I think we'd all agree we're really in a distinctive moment right now. And so much of this is resonating due to a maelstrom of political polarization and social media amplification. So an alternate title for this presentation was going to be Grifters, Groypers, and Goop. I'll get back to Goop. I have a lot to say about her. Okay, so some of you know the Supreme Court talks a lot about history and tradition. I also want to talk about history and tradition, not so much originalism. So really a 3-minute tour on how we got here. So snake oil, right? We hear a lot about snake oil. Well, what is snake oil, right? So this is a very special American thing. So when the Chinese laborers came over to work on the railroad, they brought a special salve from the water snake, omega-3 fatty acids for arthritis. Now, Americans, being Americans, decided we would make it out of rattlesnakes, literally. So Clark Stanley was the #1 snake oil purveyor. There he is, the American cowboy, with obviously zero effect, right? So that's our first. Second slide, slightly less amusing, goes back to the medicine shows. Now, medicine shows are actually started in 14th century Europe. But after the Civil War, they've been, sort of the rise of opioids and laudanum. There's a real trade in this. In fact, Houdini got a start in medicine shows. So the Kickapoo Indian Medicine Company, which, as you probably guess, had no indigenous Native American things, actually started in New Haven in 1881. This is, I apologize. It's an offensive ad, but I think it needs to be shown. And actually used a mixture of the Iroquois, Sioux, Cree, and Pawnee nations, who are all literally leased from reservation agents, right? So basically almost convict labor. And if you see up in the corner, that's Charles Bigelow. So for those of you who are in New York, famous C.O. Bigelow, it's getting a lot of attention now because Carolyn Bessette Kennedy used to shop there, right, with the whole revitalization of that. Same family, right? So, I'm here to ruin all of your beloved institutions here. So I sort of put this as sort of the indigenous woo aspect, right? Very popular, didn't really die out until the 50s. Finally, and this one is, I think, my favorite, anhelonium. So Park Davis, which is now Pfizer, right? Of course, actually went to Mexico in 1887. That's actually a picture of one of the peyote buttons. Amazing what you find on the internet, that they sent back. And oh my goodness, so they made this drug called anhelonium, mixture of peyote, belladonna, and digitalis. It was treatment for mental disorders. Now, I have looked far and wide. I cannot find a little bottle of anhelonium. So instead, I provide you the aphrodisiac, also made by Park Davis, poison on the bottom, right? So this is what we have. This is sort of the beginning of like the wellness grift, snake oil, psychedelic stuff is old. All right, let's move to the 20th century. 7-Up, right? So 7-Up used to be called bib label lithiated lemon lime soda. It was made in 1929 at the sort of edge of the Great Depression with the mood stabilizer lithium citrate, now used to treat some mental illness. It was not required. They were not forced to remove this till 1950, right? And so that's the original ad, takes the ouch out of grouch. I bet it does, right? And so why 7-Up? Well, as I'm sure all you scientists know, that's the atomic mass of lithium. Down at the bottom, that's the electrical thing. And then there's some really great trippy ad. That's from 1969. Evidently, when you drink 7-Up, especially the original stuff, that's how you feel. Okay. Who's that? Oh my goodness, Saint Hoffman, right? We all bow. And all right. So he discovered LSD. He also synthesized it. He synthesized psilocybin. Oh, he worked for Santos. Let's not forget that. What did Santos sell? Well, we have right here Del-Cid, obviously from LSD, 1947. Indocybin, psilocybin. Santos sold both as experimental psychiatric drugs. Now, of course, that's the LSD. I know just enough biochemistry to be irritating about it, right? So that's a little LSD bicycle day. I don't need to explain to this crowd. All right, 21st century. Oh, here we go. All right, Goop, my favorite, right? So I have watched her next Netflix specials. I've hate watched them, so you don't have to. And she had on her six specials. She had one called The Healing Trip. Glamorizing psilocybin retreat. So that actually is a still that I took, right? So they tried mushrooms. She didn't try any of them on camera, just all of her sad staff. So she's glamorizing this. She also has written quite a bit on her website / blog, really selling these retreats: ayahuasca, ibogaine, psilocybin, ketamine, MDMA, LSD, right? I think a lot of people follow Goop. I'm not sure that we want her to be our guide in this. The last person, the last historical slide, Casey Means, Dr. Casey Means, our once and future Surgeon General. She's also a popular wellness influencer. There's her book, Good Energy, a really strong pusher of psilocybin MDMA. She's I'm from Oregon. She, I think, flunked out of her residency there. So ask me more in the Q&A. She also wrote a cookbook on her book. So as I've told a couple of you, I'm writing a book on eugenics. I will also have a cookbook that I'll be shilling. I'll be taking, to serve man, right? Okay. So I'm just gonna leave her up there for a little bit so we can gaze upon who is now making these decisions for us. We'll get to some others. Why is this a problem? Well, the lawyer's standpoint, right? Psychedelics are existing in a largely unregulated frontier, which is not necessarily bad. What we worry about is how it is operating at the legal margins. And a lot of times we have the blend of spiritual discourse with unproven therapeutic claims. And that's where we get in trouble. And I think we see a lot of these things unregulated on the sidelines, the wellness discourse, the wellness grift. We have practices aligning the boundaries between medical treatment, religious ritual, and commercial service. And I think in these liminal spaces, we can really get into trouble. Now, I don't think the legal system is a magic fix for a lot of our problems. Most of my work is in the criminal legal system. And let me tell you, we've done very poorly with the war on drugs. We've done very poorly with the family regulation system. However, because of this danger of exploitation and harm, especially for those people seeking mental health relief outside of standard medical care, especially for vulnerable populations, people who are struggling with addiction, people who are unhoused, people who are veterans. Because of course, once you introduce psychedelics, as we are, and I think you could see this in Oregon. Now, Mason wrote some amazing, plans for how psilocybin is being used in Oregon. And hopefully at the Q&A, someone will ask me about theory versus practice, how that's worked. And if anyone knows anything about Oregon, poorly, we execute things very poorly, right? And so I think not only is there sort of this danger of the for-profit pharma tech bro companies and wellness gurus moving to exploit us, right? Okay, so here we have, here's our beautiful psychedelic world. Who is that peeking through the keyhole, right? If you can't see, right? So that is Peter Thiel, who has a tie, running that. We have Brian Johnson, who's doing all sorts of exciting things. He is running this blueprint wellness thing. And he does lots of interesting things, including like taking his son's plasma and doing shockwaves to his genitals. So lots of good ideas, but also a lot of people, he's going to live forever, right? God bless. And then there's just Elon Musk, because I want to pick on him. We know he uses a lot of ketamine, and he did some stuff in Doge. The other person we have down there, that is an actual official White House picture of RFK Jr., our secretary, doing a raw milk shooter in the White House. Right. Okay. So here's who we have either pushing or regulating. And I have to say, this is bad, not just for the public, but also for serious researchers and scientists of psychedelics. How am I doing on time? All right, so if I'm great. Otherwise, just cut my mic. All right. So what kind of problematic potential results might you see? Well, something that Jules Evans talked about yesterday, these medical tourism schemes, especially outside of the US, but being lots of Americans coming, lacking proper screening or integration support. We have lots of, like Goop is pushing these premium price retreats with untrained facilitators, right? And those I think are also going on in the US just quietly. We also have, and this is something we saw all over Oregon, we have supplement products marketed with unsubstantiated therapeutic claims. So this stuff, shrooms, also marketed obviously to children, right? Because it looks like candy, was actually not made with psilocybin, which I'm pretty, so on the, is that my right? Yeah, my right. That's the sort of molecular structure of psilocybin. It was made instead with, I'm gonna probably mispronounce this, mipracetin, which is a chemical structure similar to psilocybin and psychoactive, but totally unregulated. In fact, the New York Times, something else I hate read, so you don't have to, had a sort of scary article a couple of days ago, basically how all these fun young entrepreneurs are taking fentanyl and like adding, one or two, molecules and how you something even more dangerous, right? So there's a lot of at-home experimentation. And when that comes to the market, right? And it took a long time to get this stuff off the shelves. Finally, we of course have lobbying efforts that prioritize market access over consumer protection, right? Once, I don't mean to pick on big pharma, but let me just pick on big pharma. Once big pharma gets their hands on this, I think we're gonna see a lot of lobbying. It's going to be advertised on television. And ultimately, and this put on more of my legal glasses, this is lack of remedies for harm. So victims of this, assuming you don't die, face formidable barriers to recovery at home and abroad, right? And so you can say, oh, well, you can sue. Well, civil damages, if you can get them, are not going to fix some of the problems. Again, Jules Evans has talked really deeply about this. There's always disclaimers of therapeutic intent, there's contractual waivers, and I think a real absence of recognized professional standards. So at the worst, psychedelic wellness grift uses a combo of social media influencers, the biohackers, pharmas and tech bros, and a lot of these venture-backed unregulated retreats in an arena to exploit the public and those seeking health. So before I turn it over to my colleague, Jen. Okay, so this is Goya. Goya made this etching over 200 years ago. And I won't try to say it in Spanish, but The sleep of reason produces monsters. So that's me over there. That's my cat in the corner, right? And so you have. So anyway, beware. And thank you, Jen. Did the clicker work for you, Laura?
No.
Okay, just use the arrow. Okay. Thanks, Laura. That was great as usual. Huge thanks to World Religions, the Humanities Center, and Petrie-Flom for hosting this terrific event, and my drug law and policy colleagues on the panel, including Mason, Marks, for moderating for us. I want to situate Laura's examples within the regulatory architecture of governing psychedelics in the United States. Here's my quick agenda. I'm going to cover my 3 central claims, quickly talk about the Controlled Substances Act because Alex is a master of ceremonies on that, and I cannot steal his thunder. My statute, the Federal Food and Drug Cosmetic Act, because I'm an FDA person. Talk about the FTC a little bit, but don't trust me too much on that. Subnational laws and regulations. I'm going to talk about the states, counties, and cities very quickly, and a couple policy responses that Laura and I are still thinking through as we're going to draft this paper. Okay, so I'm going to make 3 central claims. Let me just pop them up there right away so I don't have to worry about this. First, the varied psychedelic markets that Laura just described persist not because the law is absent, but because it's fragmented across regimes and enforcement authorities that are ill-equipped to work together. And the central problem here has already been described by her. We have a hyper-regulation on one end of both the products and services involved, and no regulation whatsoever as the pendulum swings in the other direction. Second, the fragmentation produces not just gaps, but exploitable inconsistencies, a gray area where underregulated markets develop, and our grifters and groypers and goopers can take advantage. Third, and critically, I cannot emphasize this enough as a health law person, this is happening because of real clinical demand. As Mason's work emphasizes, existing treatments for depression, anxiety, substance use disorder, and other stigmatized healthcare conditions are often grossly inadequate in the United States and leave many patients without effective options, fueling demands for alternatives. And as Laura's presentation sort of points out, this is when you go back to the medicines show and all the rest of the stuff, people were very inclined to go with this sort of street medicine because medicine couldn't treat almost anything at the time. It wasn't sort of like people were like magically imagining this because there's something wrong with them. They were really seeking, out of hope, some relief from really severe healthcare conditions. Okay, let's talk about federal law really quickly. All right, the Controlled Substances Act. As we've already discussed, the Controlled Substances Act classifies drugs into 5 schedules based on their accepted medical use. We already talked about this, their abuse potential, and their safety profile / dependence profile. Classic psychedelics like psilocybin, LSD, MDMA land in Schedule 1 because they're viewed as having no accepted medical use and a high abuse potential. That's not true for some of the categories that bleed over here, like the dissociatives like ketamine and esketamine are in Schedule 3, so they're treated at the federal level like stimulants and steroids. Okay, so on paper, the rule is really simple. These substances are illicit under federal law virtually in all circumstances with a narrow research exception. In practice, that prohibition is doing far less work than it appears. Federal authorities prioritize, the DEA really prioritizes large-scale drug trafficking, not small-scale facilitators, not these smaller retreat operators. And as we've already heard, multiple people bring up states have begun to experiment with regulated access, and many localities have prioritized enforcement. So the result, the problem isn't just uniform prohibition, which is a huge problem, but it's coexisting with like this sort of tentative tolerance, and we don't know how far that will go given different regimes. All right, let's talk about the FDCA, Federal Food and Drug Cosmetics Act. I think we all know this. I don't have any time. This would be like 2 hours of presentation just to do the basics, but
There's a lengthy, expensive 10 to 15 year long FDCA approval process for new drugs. It requires all sorts of clinical trials. We've heard about these RCTs already. And I actually, in anticipation of speaking today, went back and listened to some podcasts because I was traveling from Indiana to here. And I listened to some from 2021 very intentionally and some from 2023 that were in both podcasts. It's imminent that FDA is going to approve MDMA in 2021. It's imminent. Well, they have not. And it's, I think right now, April 2026, although I'm a little loopy. 2023, it's imminent. The FDA is going to approve psilocybin. Well, it's 2026 and that hasn't happened. So I just want to point that out. The FDCA has a high standard, right? You have to prove the product sponsor has to prove with substantial evidence that the drug product is safe and effective for its intended use, its use on the label, and also has to prove that the product's benefit outweighs its risks. Okay, like I said, psychedelics are moving through that process, as I just told you, and the results look very promising right now, but I would not over rely on the predictors constantly telling us that FDA is about to approve this. So let's take a quick look at that. Synthetic psilocybin compounds are in phase 3 trials for treatment-resistant depression and major depressive disorder. And again, this morning, what the pundits are saying are potential approvals as early as late 2026 or early 2027. I'm more skeptical. MDMA, as you may or may not know, had a huge setback in August of 2024 when FDA declined to approve MDMA assisted therapy for PTSD. As I said, hopes were high in 2021 era that this was going to happen, and it has not. And then LSD received FDA breakthrough designation for a general anxiety disorder in early 2024 and is in phase 3 trials. The FDA pathway is but one pathway to psychedelic access. All these are synthetics, as we've already discussed. So what's emerged in response to this hyper-regulated, very difficult, very expensive process to get through, unsurprisingly, is a quasi-experimental marketplace, right, in which the FDA regulates drugs and formal research, but does not meaningfully regulate experiences framed as wellness, spirituality, or personal exploitation. As Laura pointed out, actors can avoid explicit therapeutic claims and often explain their experiences as healing journeys or facilitated experiences. So folks are going in. The biohacking thing, by the way, the whole thing with that, people ordering these peptides online and doing all this tech bro stuff, they're saying they're doing personal research, right? They literally are openly saying this is the loophole that we see in the FDA that we're exploiting. So I'm not making that up. That's their position. All right. And then the FTC, like I said, please don't ask me questions about this later, but the Federal Trade Commission does provide an additional layer of oversight. It's illegal under their statute to advertise illicit products. So period, full stop, under federal law, if you made any advertisement, however accurate or not, that would be against the law. It's also unlawful to make unsupported therapeutic claims. That's true also for the FDA regulation. But claims in the marketplace, like I said, are like life-changing, hacking, healing. As long as they're paired with disclaimers, the FDA generally, or the FTC has generally let this go. They've been very active in like CBD, cannabis markets. They even recently started cracking down on ketamine, but they have not done any publicized crackdown on any of this advertising, to my knowledge. All right, so subnational regimes, the state of the states, you've already heard already, Oregon, came online first with Measure 109. It allows supervised access at licensed service centers without a medical diagnosis, and you have to have a state license, but you don't have to be a medical professional in the traditional sense to facilitate. Colorado followed with the Natural Medicine Health Act and launched its services, I think, very, very recently in 2026. Again, that's another one when you listen to the podcast. It's coming out in 2025. Didn't happen. But they permit possession and personal use and supervised consumption at their state license centers. I actually looked up the cost in Boulder when I'm thinking of going skiing next year, and it's outrageously expensive. So I'll just put a pin in that. And then several other states have introduced or considering legislation. Governor Newsom famously vetoed California's, and we'll see what's going to happen there. And then I'm just going to put this up for you to see. This is what I could find the other states and counties that have done some version of decriminalization or deprioritized criminal enforcement. Okay. And then equity. These models raise significant concerns because although there is some state regulation and oversight, and that's great, they're resource intensive, time consuming, and expensive therapies. So I'm really worried that there's going to be a disproportionate lack of access for people who need it the most for the conditions that these substances are indicated for. And I think it's something we need to. Okay, last slide. Policy responses, and I promise you I'm going to sit down. While this analysis reveals structural misalignment across regulatory domains, we have proposed 4 targeted responses for consideration. Federal state harmonization. Federal prohibition isn't doing anything helpful here. And as Alex alluded to, even when you deschedule these, or not deschedule, if you downschedule these drugs, you still are left with a whole host of conflicts between the way the state programs are regulated, right? And who can do it and who can't, who needs a DA license and all the rest of this. Even if marijuana was put on Schedule 5, it has its own special, really restrictive research provision that doesn't mash with the rest of Schedule 1. Right. So we just constantly get into all of these things. Number 2, intermediate regulatory categories. Maybe it's time to just think about complete institutional redesign of the Controlled Substance Act that's more realistic and keeps people safe and safe and effective here, but it doesn't cost. You know how much it costs the new drug application is when you go to the DEA for 2026 or the FDA for 2026? $4 million. And then you pay almost $500,000 fee every year for approval as a user fee. So this stuff is just completely, right? And then it takes 10 to 15 years and you're doing all this patent stuff. It's out of control. Okay. Equity by design. As I've already said, we really need to attend to who gets access to these substances when they are permitted on the state and local level. And we also need to do enforcement against grifters, marketing psychedelics. Who knows what's even included in those as cure-alls to mitigate harmful exploitation. And last but not least, targeted and enhanced consumer protection by the federal agencies that regulate marketing deceptive and untruthful advertising to vulnerable communities. That's it for me. Thanks.
All right, and last but definitely not least, we'll hear from Santiago. And it's nice that we have people from Oregon and Colorado today.
All right, welcome everyone. Sorry I have to hold this, but I'm the one holding us from the Q&A. I'll try to go through this. I'll introduce myself, Santiago Ivan Guerra, Associate Professor of Southwest Studies. Yes, there is such a thing as Southwest Studies. The East Coast is not the only thing that exists. In the US, you'll get a sense of that. You're about to get an educational lesson on how the other half lives, if we can say that. I do also have to say, per some of the discussions about non-financial conflict of interest, I did sit on the federally recognized tribe and indigenous community working group in the state of Colorado for the Natural Medicine Health Act. Some of that influences the work that I do. We'll see how much I can say about that work during the Q&A. The premise of this talk is really kind of using the peyote sort of problem, what I've termed the peyote problem, to discuss issues around how the psychedelic renaissance really starts to show the inconsistencies of providing and safeguarding access to natural medicine and psychedelics for a particular subset of groups that actually don't fit into any of these categories that we've been discussing today, or that even were kind of referenced by Feldman yesterday in his really sort of impressive talk. The group that I'm referring to today, the Guatemaltecan Chicana OX communities of South Texas, northern Mexico, really problematize the legal frameworks that we currently have. And it really sort of problematizes how proponents have envisioned access to these plants. I'll get into that at the end. But before that, just kind of give you what I'm calling a bordered positioning, kind of like the non-financial sort of disclosure. So I am from a South Texas border Chicano Coahuiltecan community. I have ancestral ties to these homelands. I'm one of the few people that actually doesn't live in South Texas in my family. And we have ancestral medicinal use of peyote, marijuana, spelled with an H, as it's supposed to be, toloache, datura, and then a whole range of other psychoactive and non-psychoactive medicinal plants. So I come from this legacy of psychoactive plant use, but also from a legacy of border smuggling throughout the 19th, 20th, and 21st centuries. And so a little bit of how we've been talking about and how the drug war kind of looms over all of us, that some of us are still living in that drug war moment, not in the post-drug war moment. And so I have a familial impact of mandatory minimum drug sentencing. Many of my primos hermanos, my cousin brothers that sort of I grew up with, are in prison serving extensive sentences for marijuana smuggling. Even as we talk about descheduling, rescheduling, all these different conversations. And then from a more sort of academic standpoint, I'm coming to this project as a trained sort of legal medical anthropologist, but also working within borderland studies and Indigenous Chicano OX studies. And as sort of Indigenous people are off to do, we always bring our relatives and our family into the spaces that we presented. So just a couple of images showing my cousins, some of whom have served sentences, and then my aunts. All right, so why the Coahuiltecan Chicanos? So Coahuiltecan people are peyote people. You'll see in a second why that matters. They're an indigenous population comprised of various families and bands that inhabited what today encapsulates the state of Texas and the Mexican states of Coahuila, Nuevo León, and Tamaulipas. So they're crossing this sort of new imposed 19th century geopolitical boundary. This territory also overlaps with peyote's natural habitat in the region. And if you ask Coahuiltecan people, they basically say that their homelands are wherever the peyote grows. You can see that in this sort of map taken from Stacy Schaefer's work on the peyote harvesters of South Texas, of which at least one relative of mine is. And you can see the part that encapsulates the peyote lands in Texas fall right on the US-Mexico border, either in South Texas or in West Texas in the Big Bend. So many South Texas Chicanos and Northern Mexicans are descendants of these Coahuiltecans and mixed race settler populations that arrived to the region in the 1570s, way before this institution was founded. Just kind of situating that for everybody. And the movement from central Mexico to this region was actually a legal and racial move, right? One thing that we don't often think about is how race operated differently in the US than it did in other places, and particularly in Mexico, in New Spain. The sort of race and legal system were kind of codified together in really significant ways, and it kind of incentivized, you'll see in a second why that matters, the movement to other territories where the imposition of these laws, these sort of like racial codes, wouldn't be as heavily enforced. So the settlers that moved into this region are primarily Afro-descendant and mestizo populations that are escaping this legal system called the casta system. So take an example from one of these communities that was founded right on the border in South Texas, Mexico region, founded in 1753, the Villa de Mier, contemporary Ciudad Mier, Tamaulipas. The 1788 census showed that just over 40% of the population of this village was of African descent. Negro, mulatto, or lobo were the categories used in the census. And then to just draw your attention to, the lobo category are individuals of mixed African and indigenous descent. And then if you look at the census categories for the other 60%, those are a mix of, and it's not clearly delineated, Spanish, Indo-Mestizos, and Indian populations from other areas. This does not include, this is a settler population, it does not include the Coahuiltecan populations that are indigenous to that area. what happens with these settler populations is that they mix and come into contact and relationships with the Coahuiltecan bands. And we, the people from that South Texas region, are the descendants of these intermarriages that sort of occurred as part of the settlement population. All right, so one thing I want to draw your attention to is that this region of what is now the US and northern Mexico functions in this sort of like borderlands category in a different state of exceptionalism, not the good kind, as was referenced earlier. But this is where many of the outcasts get sent, right? And this happens not just for the Coahuiltecans that I'm referencing today, but we also have examples, as the Kickapoo were already mentioned, through some of these sort of snake oil salesmen. Nacimiento Coahuila is both a place of settlement for a Kickapoo band that gets moved out of the Midwest into northern Mexico as refugees from the westward expansion into the state of Illinois that was really seeking to exterminate these populations. Additionally, right, not just US-based tribes, but also mixed race tribes like the Black Seminoles, the Muskogos also live and reside and resettle in this area of northern Mexico. We also have examples of the Lipan Apache, or a group of Apache that are not federally recognized in the state in South Texas, as well as the band of Yaqui Indians, the Texas band of Yaqui Indians that were displaced from the Arizona-Sonora border over to Texas. So, kind of like a reoriented history lesson. I know we're about to celebrate the US's 250. We are not at that celebration date where we are from. So just the rundown for people that don't know, Mexico achieves its independence in 1821, largely fueled by an effort to basically tear down the casta system, the system of racial codes. And then as a result of that sort of independence, in 1821, Texas, Coahuila, those two states in northern Mexico, established an immigration process to allow for immigrants from the US and Europe to migrate into the territories of Texas, leads to the independence of Texas in 1836, annexation of Texas to the US in 1845, and then conflict over the southern territories, westward expansion, 1846 to 1848. We have a war of aggression with our southern neighbor in Mexico. And that leads to the establishment of the Treaty of Guadalupe Hidalgo. For those of you that have not heard of, this is a treaty between the US and Mexico that basically brings the end to the US-Mexico War and sets the contemporary US-Mexico border with the exception of a small part of southern Arizona. An important thing to know about this treaty, right? From a legal standpoint, highest law of the land, right? Agreements between the US and another nation, this stands in, in sort of like an important sort of like legal landscape. Interesting to know whether that functions constitutionally if a treaty and a constitution are at odds, right? You'll see why that's important in a second, because Article 8 and 9 of this treaty identified protection of property, extension of US citizenship, and quote unquote protection of the Catholic faith. Now, why is this important? Because that war ends and that treaty is signed before many of the things that are currently up for debate by the Supreme Court around who qualifies for citizenship in the US, right? The post-Civil War amendments to the Constitution, the 13th, the 14th, birthright citizenship, and the 15th Amendment around voting. That is important because, as I just mentioned to you, these are a mixed race population that under US laws of the time do not actually fit into the racial legal categories of who is a citizen at that time. So that creates a whole very complicated legal dynamic for these populations of South Texas in particular. Additionally, this is also prior to Native American legislation like the Dawes Act and the American Indian Citizenship Act that clarified application of the US Constitution and constitutional protections to individuals of Native American ancestry. And now we get into the peyote piece of all this after I've kind of bored you potentially with Western history. Here is something really important to know about what happens with peyote in the context of the US and concerns around the current sort of psychedelic renaissance. Quanah Parker, famously the last free chief of the Comanche Nation, is actually the person that more than anyone popularized peyoteism for the sort of pan-Native American community, founds a Native American church that gains prominence. But that happens actually because in South Texas, he is gored by a bull. And as you can see here from the Comanche National Museum and Cultural Center, he is treated by a Coahuiltecan Indian curandera that is referred to the Comanche by the Comanche as a Coahuiltecan, but in most other records is identified as a Mexican curandera. So we have some slippage around how these people are identified. It's important to know that peyote in the South Texas and Coahuiltecan tradition is not just a psychoactive ceremonial medicine. It is also a primary medicine for a range of treatments, fever, infections, in midwifery ceremonies, for birth ceremonies, a whole range of different applications. So now we get into the meat of it. This population fits into such a nebulous sort of ground of like US history that they don't actually play very well with all the laws that we have, right? So here are the limits of the medical model as I see it in my analysis of why Coahuiltecan people aren't actually protected in their use of peyote or the psychoactive medicines potentially at play here. The Controlled Substances Act, as was already mentioned earlier, identifies accepted medical use and the likelihood of abuse continuum. This is important because if we look at some of the conditions that are covered, that are used traditionally to use peyote as a treatment for, one of those is a condition known as susto, right? It's identified in the DSM as a cultural concept of distress. But if you ask Coahuiltecan and Mexican people, that does not actually make a lot of sense. This is the cultural concept of distress is where diagnosticians put in all these cultural illnesses that they don't really quite understand and just kind of group them together. It doesn't account for what it actually means, which is soul loss, translates to soul loss. And so the treatment of it is not uniquely a material condition or a spiritual condition. It's an amalgamation of all those things, right? The best approximation we might have within the clinical setting is a version of post-traumatic stress disorder, right? So we have an illegibility and eligibility of Coahuiltecan curanderismo and Mexican traditional medicine not being compatible with an exemption from the Controlled Substances Act and the accepted medical use. Additionally, the limits of religious freedom, as identified already in a whole range of presentations here, doesn't really neatly fit in for Coahuiltecan people because their use and consumption of peyote is not strictly a religious practice, right? As we identified through the Myers test, it would not meet the designations of a bona fide religion because it's a belief system and treatment system that's integrated through a variety of hybridized forms. And here we have the limits of indigeneity, that these populations do not actually fit into the Native American protections and designations of the American Indian Religious Freedom Act or the amendments that were proposed in 1994. Chicanos and Coahuiltecan descendants can only be licensed in Texas to be a peyote dealer. So they can, they're legally allowed to harvest the medicine, but not actually consume it. The issue with that is we only have 4 peyote dealers, licensed peyote dealers of Coahuiltecan Mexican descent. If you sign up to be a peyote dealer, you are now on a list to be in conversation with the DEA. You have to keep track of all the peyote that you harvest and allocate. And so if you're doing that, you can't actually provide any for yourself or any of your relatives. So that's put you in a really problematic legal area. Additionally, these groups are not federally recognized, and if anything, are in a very tenuous state recognition position. Now you add to this an ongoing question debate that you likely hear about here, but don't get to see firsthand. This is another problem with the ongoing debate around this population and the protections of this really significant plant medicine for these populations. The border enforcement apparatus really creates an effort for the state, right, the US government to basically police and control our southern border. Part of that is peyote is sort of critically endangered, right? So it should have protections through the Endangered Species Act. Wall construction allows for the suspension because of national security interest to be able to build wall and clear land on which there are several peyote populations without any consideration for the Endangered Species Act. So that we have a suspension of of all of these sort of legal regimes at the US-Mexico border in what some scholars call a constitution-free zone, where the Fourth Amendment, the First Amendment, no amendments of the Constitution apply to local populations. So now I'd say if the psychedelic renaissance is to do all these things that it's supposed to do, people like the Coahuiltec and Chicanos of South Texas have to fit some way into these discussions of protection from a legal perspective, right? There's insufficiencies in this framework, and something that the psychedelic renaissance and the psychedelic community needs to reckon with is the integration of these perspectives into the movement as a path of accountability. I would recommend reading Gregory Cajete, Jessica Hernandez, Patricia Gonzalez, and then kind of as a closing point, we really do need to kind of orient ourselves to the United Nations Declaration on the Rights of Indigenous People as a framework for reconciling the potential harms and ongoing harms that the psychedelic movement has caused. And I save this for the end because usually this causes people not to listen. My good friend and scholar, mentor, sister, Dr. Dwana McKay, sociologist of Indigenous sort of studies, Muskogee person, popularized this term in academia of legitimized racism, of how Indigenous people are often mistreated through systems of racism in legitimate ways that we don't see as problematic. And I see that much of what is happening in the psychedelic movement as part of this process of legitimized racism, whether we're talking about the work of Phil Deloria, who opened up this conference, and his really significant work on Plain Indian, that we see a lot happening in the psychedelic sort of practice, that we do need to hold the sort of movement more accountable for how Indigenous people perspectives and knowledge systems kind of work in and contest what is ongoing in the present, and how it's not really possible given some of these legal limitations. And I will end there.
cswr.hds.harvard.edu. Copyright 2026. The President and Fellows of Harvard College.